Good morning. I'm the trial judge in your child abuse case. You are going to waive the reading of the allegations against you. Your children are in foster care placement because the attorney for the children said that they are very afraid of you. I have worked with the attorney for the child for years and I believe everything she says. I understand you did not get served with the summons to this case. That doesn't matter. You're here anyway. If you need counsel, we have a free attorney available for you who is certified by the court. If you hire private counsel, he better behave in this court. I will not hesitate to sanction and fine him. I'll write reports to his disciplinary committee for the slightest infraction. Your motion for immediate return of your children is denied. I find there is imminent risk of harm to life or limb for all of your children. You have leave to refile the motion for immediate return of the child, but that hearing will take place over the next 4 months because my calendar is busy. I will deny your motions for privately retained psychologists to testify because of the risk of trauma to the child because of repeated psychological evaluations. So you'll have to go with what the court psychologist says. I will qualify that psychologist in the area of psychology and allow him to offer an opinion on any area he wishes to discuss. I will find his testimony credible and his report helpful to the court. I will sustain all objections as to the psychologist's qualifications, his disciplinary history, his methodology, and his reliability. That's all irrelevant to this case. I will cut short cross-examination of the court's professionals to save time. I will cut short opposition to motions filed by the Child Protective Services. I used to work for Child Protective Services and I know they are never wrong. I will deny motions to get records, reports, and other evidence. I will not allow subpoenas of either the foster care agency or the Child Protective Services. That's not important. This case is about how you abused your children. I will conduct a fact-finding hearing which I will decide based upon the preponderance of the evidence that you abused or neglected your children, and then I will dispose of this matter based upon clear and convincing evidence that you abused this child. I will conduct permanency hearings once every 6 months. You may or may not get a report from Child Protective Services in advance of that permanency hearing. If you don't file an appeal, the appellate court will show you and your attorney the seriousness of hurting a child. I will entertain motions and I will issue orders without notice to you. Right now you have an order of protection against you. There is no contact with your child until a further order of the court. If you violate this order, I will hold you in contempt here and I will report you to the district attorney's office to commence criminal prosecution against you as well. This does not violate the prohibition against double jeopardy. If any of your privately retained professionals commit misconduct, I will file complaints with their licensing committees. I see that you have an order of child support for the child. You will continue to pay child support. You do not have to see the child to pay support. I will incarcerate you if you do not pay support. Throughout this case, I will be on the bench whenever I feel like it. If I am not here, you will have to wait until my court staff tells you that the case is adjourned, and you will return months later. All motions will be continued to that date, and I will not have another judge preside in my absence. This case is too important for that. Any attorney who fails to appear before me will get an order to show cause for contempt unless they work for the government. Your failure to appear before me will result in default, and I will dispose of the case forthwith. Do you have any questions? How do you plead? This case will now be continued for the next 6 months. Have a good day.